I tried to start my presentation without my microphone. That didn't work. Can everyone see my presentation? I'm sorry, I can't see you, so someone would have to speak.
Yes, it's fine.
Yes, wonderful. All right, so just a short slide about me. First, I'm a postdoctoral researcher at the Department of Law in Bergen, together with Ignacio. And I'm a member of the HyValue project, which does hydrogen research. I studied law in Bergen and Heidelberg, and then I did my PhD on law of obligations in Bergen a couple of years ago. Today's presentation is supposed to be available to non-jurists, so I will start by explaining some basics about Norwegian law. And I, of course, will not try to go into detail. Law is a way of regulating human interaction, and it's supposed to tell us what we can and cannot do. And modern law can also be seen as a way of balancing rights and duties and distributing risks between parties in a legal relationship. And the moral standard is that rules should be fair and predictable. Because law relates to society rather than nature, it's often mistaken for an ordinary social science, but it has got its own methods, and those methods have been created to basically to make a basis for making sure that the rules are the same for everyone, so the fairness I was talking about. And so law is about finding out what rules apply and how they can be drafted to achieve a practical result. And then legal research is sort of more of the same. We go deeper into it. We create systems. We look at everything as a whole instead of just one particular problem. The way or the goal of law means that you have to have certain rules for where to find law, because you can't find it in nature or in society as such. So you need what we call sources of law, and you need to know how to use those sources, and that's basically legal methods, put simply. And those method rules differ from country to country, but will normally have a common core, typically legal acts, and they are very important in Norway as well. But we have a fairly long list, which you can see to the left there, of possible sources to law, and it's actually a longer list. Acts are given by Parliament. Regulations could be given by some sort of public administration or administrative body, but regulation have to be in line with legal acts. We also use the preparatory work so that we can see what the Parliament wanted the rule to be. Sometimes there's a mismatch between what the legal act says and what the preparatory works indicate. Then we also put quite a lot of weight on Supreme Court case law. That's a bit like in the UK or England, but not as much, you could say. So it's more like the European Union. Other sources of law exist, but they will only be considered if they are well-grounded. And that includes literature, which is what I do, administrative procedures, and cases from lower-ranked courts, the district courts and the courts of appeal. I've put guidelines and standards at the bottom there. They're private initiatives. They're not given by public authorities. And so they too are not necessarily sources of law, but if they're good, we will look at them and say that they should represent law. And then there's international law, which is not even on, yes it is. I've put international treaties. That's a tough one, because treaties are like agreements, and only the parties to an agreement are bound by it. A treaty is an agreement between states, so only the states are bound by it. When Norway joins a treaty, that means only the Norwegian state is bound by it. And then basically what the countries promise each other is that they will implement the rules of the treaty into their national legal systems. And then there are some exemptions, especially in relations to the EU, but what I said now was sort of the main rule. And then comes research, and research is really only worth it if there is a problem. So what is the problem with law, except for the constant problem focus of jurists? I said before that the purpose of law is to regulate society, meaning reality. But then reality is constantly changing, so law needs to change as well. That's not something that law is very good at, because the way law has been created makes it sort of slow moving. Then comes the problem of coherence. I mentioned before that a rule that stems from an act will prevail if a rule in a regulation conflicts with it. That's the so-called lex superior rule. We also have the lex posteriori rule, saying that if two acts are at the same level, then the latter one will prevail. And also, if there's a special rule that will prevail over the more general rule, if none of the others work. Those are so-called rules of harmonization. We interpret law so as to fit together, trying to create a coherence or an inner context in law. Texts must, however, always be interpreted. You can't make a text that's absolutely certain. You can't make it absolutely certain how to understand text. And also, as reality changes, you might have to interpret a text differently. Like when it says in the law that something must be in writing, does that mean that something must be written with an ink pen, or could a bullet pen do, or maybe a pencil? And what about an email? And these things have been discussed, so I'm not just making something up here. And then finally, there's the problem of imagination, because sometimes when you draft a rule, you simply can't think of all the problems that might come to be in the future. And so you haven't thought about something. And you still have to, well, courts still have to make decisions. So you need to sort of figure out what the rule is to be, even if someone hasn't thought of it. And then finally, we get to the hydrogen part, which is what I'm supposed to talk about today. Hydrogen is just of the starting blocks. Hardly any rules exist. That's not what investors want, so to speak. They do want so-called clear-cut crystal rules, what you could say, clear rules that are so easy to follow that you can just read them and go out and know exactly what to do, without worrying about interpretation. I've already sort of said that that's hard to get, and so what we tend to get is this sort of a mud bath. And that's an illustration. I took it from someone else. That is supposed to show that you want crystals, but then you need to make exemptions and exemptions from the exemptions and so on. So that rules in the end are not very precise, but they're very well adapted to the society that they're supposed to work in. It makes it harder to sort of trust law. But keep in mind that that hippo looks quite happy, and there's a reason for that. Because the crystal rules are very easy, but they're very strict, and the muddy rules are flexible. So you can adapt them to an ever-changing world. What we really need is a bit of both. When creating legal rules for hydrogen, we need to decide how, when, and where to do it. And I will now assess those 3 questions in reverse order. So the first question is where. There are 3 different forums. To put it simply, there's the international ones, the national legislature, and the administration. And then there are private initiatives. It's not uncommon for Norway to adopt rules that stem from some sort of international forum, the EU especially, but also others. The EU is fairly effective for an international body. In general, it tends to be a problem that in an international forum, there are plenty of countries represented, sometimes the entire world, basically, and they have different goals. So there tends to be a lot of politics in an international forum that hinders sort of the pace. So it moves ahead slowly. But then at the same time, you will, like the EU and UN, will very often have very highly skilled and well-qualified experts that are really the best in the world because everyone wants to join the UN for some purpose. The national legislator, I've said that the national legislator might lack qualified personnel. That's putting it a bit harsh, but they normally lack the best people in the world, and that's just the way it is. Also, sometimes they struggle to find enough time to do things. With all the legislation that's being made these days, you need an enormous system like the EU to really keep pace with everything that's going on. A national legislator might be less slow-moving than an international forum, but still it takes a year to make a legal act and about 6 months to make a regulation. And then comes the problem that things are moving ahead so fast that private parties, private investors, private researchers are saying we need those rules now, so we can't wait. And that's why I suggest also private initiatives. A private initiative will be, basically, it will be more expensive to the private parties. You can't, when there are no rules, whoever is to make this private initiative will have to do a lot of interpretation of the few rules that do exist and find rules that are not made for hydrogen but are quite general so they can use them. And then they, of course, have to make this standard or whatever. And then there's a risk that in the end, a law will be changed and their initiative will not be accepted somehow. On the other hand, the upside is that if they create a best practice that does work, that they will be allowed to take a very active part in the development of the law, because the legislator will look at that best practice, that standard or whatever, and say, this is good, we want to use it. And this leads on to the question of when to do things. We could do it now, but we lack knowledge, and we could wait until we've learned a bit more. But the thing is, new knowledge keeps coming, so you can never really get to a point where you can say, well, we know everything about hydrogen now, so we can just, now finally we can make the rules. And also you need to get started now in order to learn more. So we should create rules. And there are some things that we already know, so we can take that into account when making rules. If we want to make rules now. The thing is that changing acts and regulations later on will take time, so we need to think about how to draft those rules. And so we're back to the mud and crystals. As I said, more mud makes it harder to understand what the rule really is, but it also makes changes easier. Mud doesn't have to be a lot of assumptions. It could be simply the words you use and the way you draft the rule. And I've put an example here for you. It's from the Act of Nature Protection that was given in 1970. And I've chosen Section 5, but this entire act in general was considered to be very adaptable. It was, as I said, adopted in 1970. It lasted until 2009 without being changed, even though the world changed quite a lot, especially in terms of nature protection in those years. But the thing is here that it says, in order to preserve a unique or beautiful natural or cultural landscape. Well, what is unique or beautiful? And what's really a landscape? That's someone needs to decide that. And then it says areas can be set aside as a landscape conservation area. And in a landscape conservation area, measures must not be taken. All measures, that sounds like pretty much everything, so that's all right. But if they could significantly change the nature or character of the landscape, well, where do you draw the line? What's a significant change? And what's just a change? And what's the nature or character of the landscape? It's I'm not planning on going into detail there, but it's just to show that this worked, but it's not very simple. You need to spend some time interpreting this text if you want to use it for something. So when it comes to creating hydrogen law, how should we do it? How should we draft the rules if we are to do it now? First of all, we need to look at or know what we're regulating. I put a list here with ideal principles and rules. This is from a Finnish professor. It says that at the very sort of bottom of law, you've got ideals that sort of control everything. They're more like politics, really. And then at a higher level, you have principles, and they're guiding norms, and they're sort of, you know, they're more concrete than ideals, because they do tell you something about how the world is to be, not just an ideal that you want to achieve. But you can also decide a more concrete rule that says this is how we should go about. And that rule doesn't have to be in line with the principle, because you might choose to create a rule that goes against that general principle because you need it in one particular case. And the rules are sort of at the surface of law. It's what you see in your everyday life. Whereas principles and ideals, you need to go looking for them. If we create rules, they don't have to be, I've said it's specific directives. They don't have to be very specific. That Nature Conservation Act section that I just showed you, that's a rule, but it's not that specific. So there's something there, and we need to decide basically on what level we want to make the rules. In Norway, it's common to make rules, superficial rules, and then creating principle based on those rules in other countries, it might be more common to create a principle first and then create the rules. And that's also what's common in environmental law. Polluter pays principle, for instance, has given the basis for a lot of more concrete rules. I think that we should basically create MUD by creating adaptable rules. And I've written general standards there. That's the Nature Conservation Act that I told you about before. It's written as a sort of general standard rather than concrete rules on exactly how to move ahead. So it leaves a lot of room for interpretation, really, so that you can adapt it as you move on. And then we also have to use the knowledge that we already have and knowledge as we gain it. So we need to have a system for basically taking in knowledge as it comes in. One way to do it is by using regulations. That's the most common one, really, because changing an act takes so long. So you need to have a sort of general act and then more specific regulations. The way we normally do it is basically we say the administration, this particular administrative body is allowed to set regulations for this question. We don't normally set strict rules for how to use that power or how to create regulations. That leaves a lot of flexibility, which is good if, for instance, an international body comes up with something new that we haven't thought of. On the other hand, in theory, they could do whatever they want. So we should have some sort of limits to how the administration can go about and make sure that they understand what purposes they are supposed to protect during their regulations. I think I've said enough now. And of course, this will not solve all the problems that the industry has, but at least they will know the outer boundaries of what they're doing. And also, importantly, if you have pointed to an administrative body that it's in charge of something, then the private investors will know who to go to in order to get the information that they need. And that's something that they've asked for.